And good morning and welcome to the February 27th, 2025 meeting of the Texas Commission on Environmental Quality. It is 9:39 a.m. I'm joined by my colleagues, the beloved Bobby Janeka and Katarina Gonzalez, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we will inform parties and the public of the time limits for their discussion. Registration closed at 9:30 a.m., but if you would like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you're on the webinar, email agenda@tcq.texas.gov with your name, affiliation, and the item you wish to comment on. We will absolutely do our best to accommodate the request. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking, and please check to make sure your line is unmuted before proceeding. Before I get started, I wanted to thank everyone for the prayers for my son Henry. He is out of the hospital and at home, doing very well. Managed to tell his mom that I looked like the little drummer boy this morning in my outfit, which was charming of him. So he is absolutely recovering and he's getting his sass back. So I appreciate all the calls and the prayers. So with that, item number one, please.
Item number one is the consideration of the application by the Village of Grape Creek LLC for new TIPDs permit number WQ00163630001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, item one, application by the Village at Grape Creek LLC for the new TIPDs permit to authorize the discharge of treated domestic wastewater at a daily average flow not to exceed 20,000 gallons per day. This is an extremely small discharge. The commission received numerous hearing requests on this matter. For wastewater applications, the commission considers a two-step analysis. Okay. First, we determine whether a hearing requester is an affected person. If there are affected hearing requesters, then we consider whether an affected person raises issues in their hearing requests that are referable to SOA. Regarding affectedness, a hearing requester must explain how they will be affected by the application in a way that is not common to members of the general public. The hearing requester must also file both timely comments and a hearing request that identify both their personal interest in the concerns with the application that are within the commission's jurisdiction to address in the authorization. Governmental entities must identify their statutory authority over or interest in the issues relevant to the application. Groups and associations must meet additional requirements, including identifying members that would otherwise have standing to request a hearing in their own right. For TIPDs permits, we must apply the relevant regulatory factors for each requester by comparing the types and concentrations of effluent pollutants, the size of the permitted outfall flow, the types of proposed treatment units, and the distance between the regulated activity and the use. For this application, the very small discharge amount significantly affects this analysis. I believe that one of the governmental entities, the Hill Country Underground Water Control District, has established effectiveness. As a groundwater conservation district, the Hill Country Underground WCD states that it is mandated to protect water quality and aquifers within the district, which includes the location of this proposed wastewater facility and the discharge. Based on its statutory authority and the issues raised, I believe that the district has demonstrated a personal interest affected by the application and is affected. In contrast, I do not believe that the Stonewall Water Control and Improvement District cleared the bar to demonstrate effectiveness. The submission indicates that the general concerns about wastewater in the Pedernales River, but Stonewater did not indicate any intake structure, location, or how wastewater in the Pedernales would impact the operations or the government services. while they may have some authority related to relevant and material issues surrounding the wastewater application, Stonewall neither tailored its filings to this application nor described the relation to the facility and the discharge route location. I recommend declining to find Stonewall affected. Turning to the group and association filings, I believe that the Pedernales River Alliance and the Greater Edwards Aquifer Alliance have established effectiveness by expressly concerns with the application that are germane to the group's interests and identifying individual members that would be affected in their own right. These two groups raised relevant and material issues, so I would grant their hearing requests. In contrast, although some of the concerns raised in behalf of the Texas Rivers Protection Association are protected by the law in which the application will be considered, Texas Rivers failed to identify any member that would have standing on their own right to request the contested case hearing. Under the statutes and our rules, this group cannot qualify as an affected person without an identified individual member. So I would deny its hearing request. Now for the individual requesters, I believe there are 4 individuals who established effectiveness: Chris Wildenfeller, Donnie Clark, Paul Gabriel Fulse, and Lisa Fulse. These requesters own property that is located adjacent or less than a half a mile from the proposed facility and discharge route. Also, their express concerns qualify them as affected persons to this application. I do not believe that any other individuals establish effectiveness when considering this very small discharge amount. Especially given this minimal flow, I do not believe that the other requesters showed that they would be affected differently than the general public. So I would deny all remaining individual requests. I will stop here and talk to my colleagues about effectiveness. Bobby, Katarina?
I appreciate you laying it out in detail. I'm in agreement on all the different findings and recommendations for the different parties. The driving factor in this case for me really was that small amount of discharge going out to where and where those requesting parties were in regards to the outfall.
Great, thank you.
I'm also in agreement.
Thank you. Moving forward to the second part of our analysis on the issues, I'd recommend that we refer issues concerning the draft permit is protective water quality and the existing uses, groundwater in that area, aquatic life, and terrestrial life, wildlife, and the health of the affected residents, whether the draft permit complies with the applicable site characteristic requirements and the requirements to abate and control nuisance odors, and whether the application contains sufficient and accurate information to develop a draft permit's daily average flow limitation and discharge route. I would also recommend denying all requests for reconsideration. I do not believe they raised relevant and material information for the commission to consider. Finally, I would recommend a 180-day hearing duration. Bobby?
I'm in agreement.
Also in agreement.
Right. Do we have a motion?
I move that we grant the hearing requests of Hill Country Underground Water Conservation District, Pedernales River Alliance, Greater Edwards Aquifer Alliance, Chris Weidenfeller, Donnie Clark, and Paul and Lisa Fulse. Deny all remaining hearing requests and all requests for reconsideration. Refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit is protective of water quality and the existing uses in the receiving waters under the applicable surface water quality standards in 30 Texas Administrative Code, Chapter 307. Issue 2, whether the draft permit is protective of groundwater in the area. Issue 3, whether the draft permit is protective of aquatic life and terrestrial wildlife and the health of residents in the immediate vicinity of the proposed facility and discharge route. Issue 4, whether the draft permit complies with applicable site characteristic requirements and the requirements to abate and control nuisance odors as set forth in 30 Texas Administrative Code, Section 309.13, and Issue 5, whether the application contains sufficient and accurate information to develop the draft permit's daily average flow limitation and discharge route. I further move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued, and that we deny all requests for reconsideration.
I second.
All those in favor say aye.
Aye.
The motion passes. Thank you very much. All right, let's go to item number 2, please, Mary.
Item number 2 is the consideration of the petition filed by Bartlett Farm LLC for the creation of Bartlett Farm Municipal Utility District of Williamson County. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
I'll give everyone a second to move. All right, item number 2. Before us is the consideration of a petition for district creation with additional road powers for the Bartlett Farm Municipal Utility District of Williamson County. For district petitions, the commission reviews hearing requesters to determine if they will be affected in a manner different than the general public. The TCEQ received 1 timely hearing request on behalf of Williamson County. This proposed district will be entirely located within Williamson County, and the county noted the authority it has over many aspects related to this proposed district, especially with regard to road powers. Therefore, I agree with the ED and OPIC, Garrett, that's you, that Williamson County qualifies as an affected person, and I recommend granting its hearing requests and referring this petition to SOA for hearing. Bobby?
I agree, and just want to reiterate the diligence that I believe our staff conduct in undertaking these reviews. And I think there's an enhanced degree of public interest and attention on these matters right now while discussions are underway downtown. And I just want to reiterate my view that I see on clear display for this item that our agency undertakes to simply carry out the duties charged to us by the legislature. And as the impositions or requirements or restrictions that creation of these districts by the legislative instrument, as that's at the front of everybody's attention, the expectations may come around and be placed before us. And my view is I think our agency is up to that task. We stand ready for it. This is an area where we operate as directed, but we have tangential expertise, the ability to look into some of the economic or taxing considerations for these regulatory instruments is frankly outside of the environmental science wheelhouse that our agency typically resides in. So I think this is a very important and critical duty, but it's one that we take with a little bit of cross issue complexity in hand. So I think it's one that we'll undertake what the legislature directs us to do as they may evaluate a new level of rigor as necessary. But we look to the full degree of the different pieces of information that we get on these requests. So I know I'm a little off dancing on the line of going off topic on it, but I appreciate the reminder for this item, and I think that's appropriate. Agree with you. Thanks.
Thank you, Bobby. Well said. Katarina?
I see it as you do.
Do I have a motion?
Yes, I move that we grant the hearing request of Williamson County, refer the matter to SOA for a contested case hearing on the petition, and refer this matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling process.
I second.
All those in favor say aye.
Aye.
The motion passes. Thank you very much. Mary, item number 3, please.
Item number 3 is the consideration of the application by the City of Hudson Oaks for new TIPDs permit number WQ0016323001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Excellent. Thank you very much. Before us for our consideration is an application from the City of Hudson Oaks for a new TIPDs permit to authorize the discharge of treated domestic wastewater at a daily average flow not to exceed 1.19 million gallons per day in the final phase. We received 1 hearing request from Dav Oil, Inc., doing business as Dave Estates, raising several concerns, including how the discharge effluent will reach the receiving stream, ownership of the discharge route, and the capacity of the receiving waters, including flooding. In my review, I find that based on the parameters of the discharge, the location of the discharge route with respect to the requester's property, and the concerns raised by the requester, the Davis Estates demonstrated that it may be affected in a manner different than the general public. Several of the issues raised by the requestor, such as flooding, are outside the Commission's consideration in a wastewater discharge permit review. However, the issue raised by the requester relating to whether the discharge route is properly characterized is relevant and material to the Commission's determination in this matter. So I would grant the hearing request of Davis Estates and refer this matter to hearing the issue of characterization on the discharge route. And I would set a hearing duration of 180 days. Bobby?
I'm in agreement.
Katarina?
Also in agreement.
All right, do I have a motion?
I move that we grant the hearing requests of Dab Oil, Inc., doing business as Dab Estates, refer the application to SOA for a contested case hearing on the following issue: whether the proposed discharge route is properly characterized in the application and will function properly as an operational feature of the facility, and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Motion passes. Thank you very much. All right, item 4, please.
Item number 4 is the consideration of the petition by Ava Road and Rummelin Road Farms LTD for the creation of North Fork Municipal Utility District of Williamson County. The parties have been notified that the commission will not take oral argument, but may ask questions. Those who have signed in will be noted for the record.
All right, good morning. This matter involves a petition filed by Ava Road and Rummelin Road Farms for the creation of the North Fork Municipal Utility District of Williamson County. For district petitions, the commission reviews hearing requesters to determine if they will be affected in a manner that is different from the general public. TCEQ received one timely hearing request on behalf of Wilson Springs Prairie. Wilson Springs Prairie owns property adjacent to the proposed district and expresses concerns about runoff from the district, a statutory factor that the commission is required to consider when reviewing district petitions. As a neighboring property, I believe that Wilson Springs Prairie could be potentially affected by runoff in a manner that is different than the general public. Therefore, I agree with the ED and OPIC that Wilson Springs Prairie qualifies as an affected person, and I recommend granting its hearing request and referring its petition to SOA for a hearing.
I agree.
Also in agreement.
All right, do you have a motion?
Yes. I move that we grant the hearing request of Wilson Springs Prairie LP, refer the matter to SOA for a contested case hearing on the petition, and refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process.
I second the motion.
All those in favor say aye.
Aye.
The motion passes. Thank you. All right, let's go to 5.
Item 5 is the consideration of material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code, executed between September 1st, 2023 and August 31st, 2024. And the Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Roger Doobie, Purchasing Supervisor of the Financial Administration Division. I have with me Chris Gobert, Procurements and Contracts Manager of the Financial Administration Division. We're representing the Executive Director. This item contains the material changes made to the contracts and purchases for the goods and services between September 1st, 2023 and August 31st, 2024. Reported material changes include extensions of the contract or completion of work for 6 months or more, or an increase of consideration of 10% or more. In accordance with section 2155.088 of the Government Code, the Executive Director presents these items for your considerations. I'm available to answer any questions you may have.
Thank you so much. Any questions, comments? Has anyone signed up on
I have
this?
some questions.
Oh, yes. Go for it, Katarina.
Just kind of generally, you know, in the age of us looking at government anew, on the contracts, did we look at renegotiating any just to make sure we're getting like the best value?
Yes, that's why some of them, they're increased because you may have started like, let's take small business or the environmental trade fair.
Mhm.
You rent the facility and then you add the services the closer you get to the actual environmental trade fair. But the 10% is an increase or renewals. Those are renewals. So if it increased 10% or more, that is the increase that's showing on the report I gave you.
Okay, I'm not totally following that.
So you said, do we negotiate to get the best rules? Yes, every
Mhm.
contract that we put in place, we go into BAFO, best and final offer, to make sure that we're getting the best value for the state. But I'm saying in this situation, because the 10% increase, those are either renewals or extensions based on a best value.
Okay, but most of these are best value, best and final offer.
Yes.
Okay.
Now, this particular item today are POs. So let's say you take a cell phone PO and you have multiple cell phones on it. If you add more cell phones to it, that would increase it by 50%, but that's still best value because you're utilizing a pre-established contract like DIR, which is giving you the best pricing, and then you still go into BAFO with those POs as well.
Okay, thank you.
You're welcome.
No, it's a great question, Katarina, because it's not our money. It's taxpayer money. So appreciate your due diligence on this. OPIC?
Good morning, Chairwoman, and good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports approval and issuance of the ED's proposed resolution that acknowledges material changes to contracts for goods and services.
Excellent. Thank you, Garrett. I want to thank the ED staff for your report on these material changes to contracts, and I'm ready to move forward with the approval of the resolution, acknowledging the changes, and a reminder that it's not our money. So every cent has to be accounted for. So with that,
Very well said. I move we approve issuance of the Executive Director's proposed resolution acknowledging the material changes to contracts for goods and services as described in the TCEQ Interoffice Memorandum of the Commissioners and Executive Director dated February 27th, 2025 in docket number 2025-0113-MIS.
Second?
all those in favor say aye.
Aye.
Motion passes. Thank you. Thank y'all very much. Appreciate y'all. All right, Mary, let's go to the enforcement docket.
Okay, give everybody a second to get up to the table. Okay, that takes us to our enforcement docket. Today, those are items 6 through 26, and the executive director is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 26. The total assessed administrative penalties are $664,944, with $117,224 deferred, $127,544 applied toward supplemental environmental projects, and $420,176 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Questions?
I have a question. On item number 9, I see that the ordering provision appears to have allowed the respondent to continue to operate while it waits a permit. And could you tell me what the thinking is behind that?
I flagged that too.
Good morning. For the record, I'm Amy Sedemeyer with the Enforcement Division. So for this particular case, we did allow for the option to either cease operating or submit that application to get coverage. That is our typical practice. We do try not to, I'm sorry, give me 1 second and let me.
Hey, Amy.
Yeah.
For item 9, I'm concerned that the ordering provisions appear to allow the respondent to
Yes.
continue to operate their concrete batch plant if they apply for a permit as opposed to obtaining a permit. I would remand this to the ED for further case development to pursue an ordering provision that doesn't allow the operation until the respondent is fully authorized.
Yes, ma'am. Absolutely. We'll take that back.
Is that okay?
Yes, I would prefer to see a more stringent technical requirement in item 9 to require them to immediately cease their operations until they receive a standard permit, registration or air permit, which is my understanding of our standard practice, because I'm concerned that this ordering provision could incentivize aggregate operations to start operating without a permit if it becomes our practice to allow unauthorized operations to continue while they apply for their permit. So I would also like to see that remanded back to the ED to include that technical requirement.
Okay. Bobby?
I'm still chewing over the context of having multiple different programs. We've just authorized this relatively recently on a different area of our agency's authority in a similar manner to a different entity that I don't know that we had the same concern on. So I'm fine on taking the time. I just don't understand where we do or don't want to signal to the public that enhanced caution. So I appreciate the flag. I'm willing to go along today.
All right, let's remand. Well, we'll do a motion. Yes, OPIC.
OPIC has reviewed each of these enforcement items, and with the exception of item 9, we support adoption of all the orders presented by ED staff.
I can make the motion if you'd like.
I believe we have someone signed in to speak.
So on item 7, we had an individual available if the commission had questions, but on item 13, we had Mr. Robert Azarello signed in virtually. A moment ago when I inquired, he wasn't signed in, he wasn't on the line, so I think the silence should indicate that he is still not joined us, so I think we can move forward.
Okay. All right, do you want a motion?
Sure. I move that we remand item 9 to the executive director for further case development and adopt items 6 through 8 and 10 through 26 as recommended today by the executive director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
The motion passes. Thank you.
Item 27 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this matter.
All right, Amy with pink hair.
Yeah. Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Katanjali Yadav of the Litigation Division. We're here to present the monthly enforcement report for fiscal year 2025 through December. There were 340 effective administrative orders issued, and of those, 33 contain supplemental environmental projects. These orders assessed a total of $4,635,859 with a payable amount of $2,833,099. $1,184,889 are to be paid towards supplemental environmental projects. 4,684 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 468 enforcement action referrals have been received. There are 3,084 pending administrative orders with 1,479 cases that are on the backlog. 127 cases are pending at the Attorney General's office for representation in district court, and 0 judgments have been issued. 1,403 cases are being tracked for compliance. We're available to answer any questions you have.
Thank you so much. Any questions?
No, thanks for your work.
Opic?
We have no comment except to say that we appreciate staff's report.
I'll note that no one has signed in on this. Wonderful. Thank you, Mary. As always, I appreciate the work that goes into putting this report together, as well as all the work that underlies the numbers in the report. Colleagues, anything else you'd like to add? Nope. There's no action necessary on this item, so Mary, you can call the next item.
And once again, give people a chance to play musical chairs. Item 28 is the consideration of the adoption of proposed amendments to 30 Texas Administrative Code Chapter 30 regarding occupational licensing and registration for legislative implementation. And the Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Rebecca Morgan with the Occupational Licensing and Registration Division. With me is Haya Zeman, Deputy Director of the Occupational Licensing and Registration Division. Additionally, Aubrey Powelka with the Environmental Law Division has joined virtually. This adopted rulemaking implements 3 bills from the 88th regular legislative session and incorporates staff recommended changes. The adoption implements House Bill 1845, which requires TCEQ to establish provisional licenses for Class D wastewater and public water system operators with no high school diploma required. Additionally, the adoption implements HB 2453, which allows licensing agencies to issue a digital license in lieu of a paper license, and Senate Bill 422, which sets requirements for an application from qualified military service members, veterans, or spouses. The adoption also requires public water system operators to take resiliency training. The adoption also reduces the number of continuing education credits required to renew the Leaking Petroleum Storage Tank Project Manager license and update training terminology to be consistent with current training technology and policies. The proposed rules were published in the September 13, 2024 issue of the Texas Register. A public hearing was held on October 10, 2024, and the public comment period closed on October 14, 2024. The rule team did receive some public comments, and based on those comments, the rule team made substantive changes. The proposed rulemaking include provisions to require all applicants for new and renewal licenses to undergo FBI fingerprinting as the only method to provide their criminal history information unless a waiver was requested and approved. TCEQ is withdrawing this requirement from the current rulemaking to further evaluate stakeholder feedback on this issue and reconsider the requirement for future rulemaking. In the meantime, applicants will continue to have the choice to voluntarily subscribe to the fingerprinting service as one of the ways to provide their criminal history information. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 30. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Rebecca. Has anyone signed in on this item?
No one signed in.
Opic?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorneys, and staff. For the record, I'm Jennifer Jameson on behalf of OPIC. OPIC has reviewed this rulemaking and supports adoption of the amendments to Chapter 30 as presented by the Executive Director. OPIC specifically appreciates this rulemaking's expanded access to occupational licenses by creating a provisional license for Class D wastewater and public water system operators with no high school diploma. In addition, OPIC believes that issuance of digital licenses in lieu of paper will promote efficiency in agency processes. Thank you, and I am available for questions.
Wonderful. Thank you so much. I'd like to thank staff for their efforts in this rulemaking, including their thoughtful consideration of and response to comments. I'm ready to move forward with the adoption of this latest version of this rule as proposed by the ED. Bobby?
I'm as well. I think it represents a excellent, earnest effort to accomplish the usual list of tasks, some of which seem to be a little impossible looking at the timing of some of the dates and imagining how other states may or may not interact expediently, but I appreciate where we've undertaken to be responsive to statute and also, I think, set our staff up for success. So, thanks.
I have some thoughts on one portion of the rulemaking.
Okay.
First, I want to say, I think overall, this was a great job, especially the provisions related to veterans and military members and their spouses. That's super important. One of the things that I worked on when I was in the governor's office was occupational licensing reform, particularly for veterans and their spouses. And so I know that importance to the governor on those issues, especially in making sure that they have expedited licensing, right? I do have some concerns that the legislation says 30 days for this. I understand staff's concern that other jurisdictions may not get back to us in a timely way, but I don't think it's the legislature's intent for us to just change our rules and say, we're not going to do that. I think it's incumbent on us to figure it out how to do it. And I was at the State of the Judiciary yesterday, and Chief Justice Blacklock had some very good remarks, and I just kind of want to highlight this for staff because this is my way I think about it. He said, "Let me talk about the court's obligation to the legislature, which is to faithfully and consistently apply the laws that you write. Our promise to you is to apply the laws you write based strictly on their text. We will ask ourselves what words have been enacted into law and what do those words mean to the ordinary reader of English? That's it. We don't ask ourselves, did the legislature really mean what they said, or wouldn't something different be more sensible? And we certainly don't ask, do we like this law or not? The text of the statute is the law, whether judges like it or not, and we're bound to follow it. And the words of an enacted bill, not the aspirations of the bill supporters and not the instructions sent to ledge council, are what has passed both houses and the governor and thereby achieve the status of law. And our obligation is to follow the text that you enact and only that text." So with that, I do have a concern in the rule. I understand that staff's concern about the other jurisdictions delaying, but I still think that we should give effect to the plain language of the statute.
Bobby?
Do you, Commissioner Gonzalez, see a necessary change to this version before us?
I think there's
support that?
several courses of action we could take. One, of course, we could just adopt it as is, which I don't think remains faithful to the statute. We could also remove just the additional time provision when staff hasn't received confirmation of licensure, or we can remove the entire reciprocity provision and ask the ED to reevaluate that particular aspect.
I'm not sure which of those three paths most embody the spirit of following what appears to be an impossible to implement statutory direction in terms of having a 30-day effective date that kicks in, but also an implicit obligation incumbent on us to ensure the issuing jurisdiction we had that reciprocity. They've gotten back to us and ensured, yes, what this person before us alleged. I could see our staff being in the hot seat from both directions, frankly.
I
It's
can
impossible
too.
task.
And I again acknowledge that concern. I think then it's kind of incumbent on us to figure out what a process would be to work. And if we can't, then I think that's when we highlight that this provision maybe needs some adjustment to the legislature, and then they will tell us what they want us to do. But I don't think we should start with, we're just going to automatically give ourselves more time.
Okay. I would recommend that we defer this item until the next agenda. No?
We can't because the entire rule project will die because of the 6-month Texas register limitation.
All right.
If you'd like to take a recess, we could visit with OGC attorneys during that.
Yes, let's take a 10-minute recess and figure this out. Thank you. Howdy, y'all. We have been working on a compromise, and we will be floating that to ED staff. So 5 minutes, please. Excellent, thank you. All right, has everyone had a chance to review?
Would you like to distribute these? to
Yes,
colleagues?
I would. All right, friends, what do we think? Katerina?
I've reviewed the two versions. I just got one more version, so I'm not sure if there's any explanation or additional comment you want to provide on it, but I think the version that includes, that keeps 4 in subsection 4, ending with unless the application is deficient, striking the other 2 subsections that previously qualified deficiency or an outstanding response from out-of-state jurisdiction. I'm fine with that version. I think that's my preference of the 2.
I'm good with that version as well.
Excellent. Well, I move that we adopt the proposed amendments and additions to 30 Texas Administrative Code, Chapter 30, occupational licenses and registrations, except with the changes that have been circulated. Do I have a second?
My second.
All those in favor say aye.
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 The motion passes. Thank you.
Could I make a quick comment, though? As staff is working to implement this, and if there are concerns and things that we need to address later, please raise them. We want to know. We know you work really hard.
Thank you. We appreciate that.
Items 29 through 33, please.
Items 29 through 33 were continued until the next agenda. So that will bring us to the items for executive session, and the commission will meet in closed session in room CR 246 of the Texas Workforce Commission. Say, just go straight there
Excellent.
at approximately 10:35 or when we reach the room.
We're in recess.
The commission met in room CR 246 of the Texas Workforce Commission for closed session from 10:43 a.m. until 11:14 a.m. on item numbers 34, 35, and 37, as posted in notice to pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned. The time is 11:21.